Law, a series of podcasts focused on insights and learning pertaining to the implementation and use of AI in legal practice, with hosts Ian Hull and Suzana Popovic-Montag from Hull & Hull LLP, brought to you by counsel.ai.
Hi, and welcome to another episode of A Better Place to Be, AI in the Law. I'm your co-host Ian Hull with my partner Suzana Popovic-Montag from Hull & Hull LLP, a Toronto law firm, and what I would describe as a forward-thinking AI firm. And we are pleased to be back for another episode of our podcast.
Welcome, everyone. Thank you for joining us. Today, we're very excited to have our first special guest is going to be Doug Higgins, who is the Chief Innovation Officer of CNSL-ai. And welcome, Doug.
Suzana, Ian, thank you for having me. It's a pleasure to be on the podcast. Very exciting.
So, Doug, we know that you started out your career for a couple of years as a lawyer. And so you saw the litigation side, I think, for the most part of your practice. And I'm just wondering if you could share with us, what is it that took you from that to the Chief Innovation Officer of CNSL-ai? And tell us a little bit about what CNSL-ai actually is.
Sure. So as you may recall, one of the things I think kind of across the board, people started hearing whispers about, oh, this AI thing's coming down the pike over the next couple of years. And that was probably summer 2004. And so being involved at Hull & Hull, we started out kind of with a committee approach. I think that's fairly standard for a lot of firms where they say, let's get a group of people together. Let's talk about how different roles, partners, associates, people who are in support roles, how are we wanting to use AI? What do we want to get out of AI usage? And we looked at a whole bunch of different products. We looked at kind of all the big players that are in the space and did trial evaluations, and we looked at costing, and we looked at all the different capabilities. And over time, that role kind of, for me personally, was something that kind of naturally grew into something that began to kind of run in parallel to my litigation practice. And at a certain point, there was this decision of, okay, this has gotten so big and so fruitful that we want to try and find somebody out there who can step into these shoes. And looked into the marketplace, and we spoke to people across Canada. We spoke to people in the States who come from a legal background, people who were from a purely tech background. It was kind of like a Goldilocks situation of we couldn't find, that person who had that kind of bespoke set of skills, the right fit for the firm. And so that was kind of where the decision was made of, okay, look, there's a gap here. There's a lot of firms, a lot of lawyers who are struggling with this question of how do we actually use this technology in a way that's going to make a difference for the practice. And so that's kind of the origin story of CNSL-ai. And since then, we've been working with firms across Canada and looking into the United States as well.
Okay, so Doug, one of the things that we as lawyers struggle with is managing any change. And the movement of change, and you've taught me this lesson, is we're on a bullet train and it's just coming out of the station, and we're probably at 50 kilometers an hour, and it's going to get up to 300 kilometers an hour. It's better to get on the train sooner than later, because once it's at 300, it's hard to jump on. I like that analogy, but I also understand that for lawyers, for us to change our file management and our practice management, it is not just about getting used to the new tools, it's about changing your mindset. What's a starting point that you approach lawyers with to just at a high level emphasize or at least introduce them to the concept of AI and how it will be affecting their practice?
Yeah, I mean, it's a really good question. I think that where most firms are, going to want to start just from kind of a position of self-interest, right? At the end of the day, the law firms are businesses. I think the logical starting point is to look at, okay, where are kind of the key areas of inefficiency? For a lot of firms who are consumer focused, who are working with ordinary people, working with members of the public, consultations can be kind of a sticky wicket, right? Because you're meeting with people you don't necessarily know what's happening on the back end of the file, whether it's the facts, the law, has this kind of run afoul of some limitation period. And so a lot of firms I have observed are spending quite a lot of time doing preparation for these consultations. It's a key part of the business. You have to keep that wheel turning, keeping people coming through the door. But that time isn't necessarily productive from a strictly kind of revenue generation standpoint, right? Lots of prep time, a lot of like review time spent going through the materials that you might get from a prospective client, but that file might not actually go anywhere, right? And so I think when I'm speaking to kind of law firms who are looking at this at the really preliminary stages, I think an important piece is looking at consultations because number one, it just financially makes sense, right? There is that incentive to say, hey, look, buy into this. But on the other side of things, from a skills perspective, from a technical perspective, those pieces are a lot easier to learn. They're a lot easier to implement. And because we're talking about something that's like that, the real outset of the file, it doesn't take that much process change to start there. And I think there, once people kind of see that idea click of, oh my God, this can save us so much time and we can do more of these, I think you start to see people click and saying, well, hang on, these procedures, these ideas of how we use AI worked so well with our consult process. What about, client intake? What about litigation preparation? And so there's just so many different ways that sort of kind of learning episode can go in.
So what is a sort of a tangible illustration of what you would say you could implement on the at the consultation level to get the sort of your toe wet in the water?
Yeah, totally. So I mean, I think an example that would be applicable to Hull and Hull. Somebody comes in and they say, hey, look, I'm the beneficiary of a trust. It's rather complex. It's got a bunch of different investment and bank accounts. And they say, I feel like I'm not getting the whole picture. Here's what I do have. And they give you 10 years of financial statements. And those might have months missing. They might have pages missing from those transactions. They might have a whole bunch of correspondence that they're saying, this is what I've been told, trust. And what you are able to do is instead of spending hours and hours digging through all that and saying, okay, look, we have 600 pages of bank statements and I'm going to have a student and an associate go through this. I'm going to spend my own time preparing for this meeting. What you can instead do is kind of develop some standardized procedures for AI to go through those materials. And this way you can have it kind of immediately flag saying, hey, look, you're missing statements across the board from 25. Here maybe are some suspicious transactions. There's a whole bunch of money going out kind of on a recurring basis. And that can refine that prep process. It might just lead you to ask better questions during that consult that might entice that client to say, look, this guy really knows what he's doing.
And what about any tools that you can do to help with the reporting out on these kinds of meetings? Is there something that people should be thinking about as part of the intake process and those initial consultations?
Definitely. So I think I would, Suzana, break that into two pieces. The first is the question of like written reporting. When we are preparing the longer form reports back to clients, I think AI has a really important kind of corollary role. It's running alongside where the lawyer, I think, still should always be in the driver's seat. The driver's seat of preparing that correspondence with the clients, but on reviewing the facts, finding out the key pieces, facts and figures, dates. That's where AI really should be something that I think kind of across the board lawyers should be using because those efficiency gains. Number one, that time doesn't just disappear, right? You can reallocate that into producing better work. On the flip side, and I think this might be kind of more directly what you're getting at, is the idea of do we want to be using these kind of AI note taker tools, and how do those fit into our practice? I think the kind of we're experiencing a bit of a sea change, where in the past what we would have a lot of the time we'd have a senior lawyer and a junior lawyer both on the call. I expect that will change, right? As the public becomes a little bit more educated about kind of what AI can do, I think there will be more cost pressure. And the key consideration really, I think, for most lawyers using this stuff is just making sure that these tools are appropriately set up to protect confidentiality and to make sure that this data is being retained in a way that is secure, maintains privilege, and it's not just kind of, disappearing into the ether.
So we had, Suzana, we had experience, and let's just start talking about some of the tools we've been working through. We first started out with Otter. It's a terrific tool. We used it more as a transcription tool. We weren't able to convert some of the sub benefits that we'd call it. One of the friction points that we found with Otter was that it was being saved in, obviously these are all enterprise tools, so there's no question that their confidentiality is preserved, but we ended up more concerned about where that was being saved.
Right.
And that Otter we weren't 100% sure with Otter where it was being saved. It's because we're a Canadian law firm and we wanted to make sure. Our regulator hasn't caught on to this, that hasn't really told us that we're not allowed to, but it's just a safety concern that we looked at. So we moved to Fellow.
Yeah.
And I will talk to Doug in a minute maybe about Fellow, just because we've been using it a lot. And we've also, I think it's been more, for me anyway, more user-friendly to convert some of these additional tools within it, i.e., converting it into a quick reporting email after you've recorded it, instead of just a transcript, which is important.
Yep.
But we were able to turn it into a quick email, a to-do list, a summary. Now, Otter does that too. So I'm not suggesting that they don't have the same powers, but for us, because Fellow was being saved in Canada, that was just an added bonus. But I'm my own personal view, and I'm not running down Otter. My own personal view is I think Fellow is just a little more user-friendly than Otter was for me, but that's been because I wasn't paying enough attention at the early stages.
Yeah, and I think we're going to see that with all of the tools that we're using in, because we've got that malleability of being able to move on to different platforms if we have to as they get better, because we're still in the very beginning stages of full-on implementation of AI, but it's only going to get stronger and better. And being able to sort of keep ahead of that curve and ahead of that bullet train you keep talking about, I think is the real key for practitioners.
Yeah, one of the things too that you hear a lot of lawyers talk about is the costs.
Yeah.
And maybe Doug, we can talk to you a little bit about, because I know at CNSL-ai you do spend a lot of time managing the costs of the implementation of it. Negotiating the initial contracts, making sure that you're not getting into long-term contracts that you can't, bob and weave into a different tool and things like that. Pricing is in Canada anyway, you're looking at easily $500 a lawyer a month. And that's just probably your starting point when you put on a Copilot or a LexisNexis tool, or you put on Copilot with co-counsel, and or and then you throw a Fellow into it. You have to be ready. You got to buckle up for the pricing on it. But that's not something that you can it's sort of like not buying typewriters. When my dad first started, he bought an IBM Selectric that actually typed ahead of your keystroke. So we, as lawyers have to buy into technology. But Doug, so tell us a little bit about the way you approach the pricing and the management of the costs of the AI tools.
Yeah, and I mean, thank you, Ian, for kind of highlighting one of the things that we do with CNSL-ai is, if we're working with a firm that hasn't gotten to the stage where they've already committed to an AI tool, many times that already is the case. They've been using it for a while, but sometimes, we'll be working with a firm that's saying, hey, look, we actually just need some guidance at that super preliminary stage where we haven't even picked which tool is going to be the best fit for us. And I actually think this is one of the most important decisions that firms can be making, right? Because as you pointed out, both you and Suzana were saying, all of these contracts really are kind of on an enterprise basis. Most of the time, you're not able to approach these on a month-to-month basis. Most of the time, it really is saying, hey, look, you're going to be locked in for at minimum a year contract on this, and they're not cheap. So I really do encourage people to spend the time and properly evaluate the tools and make sure that they're meeting all of your needs at the outset, and don't assume that there's features that, you think, okay, well, if ChatGPT can do it, surely this can as well. The nature of legal software is that there are rules and restrictions in place. And again, we need to have those from kind of a confidentiality perspective. But I guess, yeah, to more directly answer your question, I think the key pieces here for any law firm across the board. Doesn't matter what type of practice it is, how big, how small. The key piece is that you need to make sure that this is a tool that is fit for legal practice. And so that means two things. Number one, all of the data and correspondence, the chats back and forth between you and the tool, those need to be fully confidential. The AI tool is going to be calculating that, and there is kind of some transmission of that data. That is just kind of the nature of how the technology works. But you do need to make sure that it's not on a basis where when you send over, a client document, that provider is not keeping that document permanently. Second piece of this is just that training idea. I think a lot of people are a little bit unclear on what training is. And essentially what it is an AI tool. And this will be the case for any free model. And frankly, most of kind of the consumer grade paid stuff as well. When we work on something and I ask a question or I give a task to an AI tool and it chews on that and gives me a result back. Yes, I'm getting an output from that, and that's kind of my deliverable. But on the back end, as an example, OpenAI will keep the learning experience of here's how you complete a particular task, and it retains some of that information. So that's on the consumer side of things. Where legal AI, legal purpose AI is distinct is that it's not doing that. And that's really, really important to highlight for people, just because if there is training or retention, you really can't be using it for any legal work.
So Doug, what do you do though? I mean, how do you go about a firm that so let's just say they've already got a core tool like CoCounsel, but they want to enhance their AI library. What are you doing with these companies? How are you managing the bringing the new tools in and negotiating and so on?
Right. So if we're coming in just kind of from a blank slate, they don't have anything. One of the things we can do is we can look at kind of the proposals they're getting from the vendor saying, here's going to be your pricing, here's the number of seats, here are kind of the features that come with it. And that last piece is really important because I think a lot of people look at kind of the flat, the base model of an AI package and they say, okay, this is all we need. Well, hold on, because do you have something that is able to really crisply integrate with your document management system, right? When we're talking about managing a litigation file, we're not talking about 10 documents or 100 documents. These very often, are in excess of 10,000 documents. So is there a solution kind of cooked into that that's allowing you to get direct access to those? So I think one of the things that we help with when we're working with people at that very kind of early stage is, okay, here's what you actually need. And when we start to get the numbers back from that vendor saying, here's what this is going to cost you, we can give kind of some guidance saying, look, here's where you're probably able to push back a bit. Things like where, a proposal is made of saying, we'll give you a cost reduction, but you have to lock in for 4 years. Again, that's something we guide on. We can say, look, you don't know where this technology is going to evolve over the next 4 years. And so maybe you want to be a little bit more cautious about locking yourself in. This idea, as you put it, to bob and weave with the changes.
So it's funny, I call it the Clio effect. Like years ago, I mean, legal software isn't rocket science. There's only a few big players, Clio being one of them. And one of the problems is that, early on, whatever you go into, you're going to be, you need to invest the time, the training, and you're going to just realistically be stuck with it. Yeah. And so, like you said, Doug, looking forward is so important. And with, for example, at our firm, we were actually throughout North America, but PC Law was the dominant docketing and billing filing firm for software for almost my whole career, over 35 years. Mm-hmm. And we've moved to Solunos recently because it's cloud-based and PC Law just wasn't keeping up. But the point is, every time we looked to move and a new shiny object came on the table, we're like, oh, this looks like great. They're catching dockets easier or whatever. Be like, oh my God, we got to lift ourselves out of a system that is so trained and so built in and so on. And we weren't early adopters to get out of a program that probably we should have got out 5 years ago because of that tension. And we're not a huge firm, but we've got 25 lawyers, probably 30 or 40 users, plus staff. So that's so important, isn't it? Just to make sure you get some advice and you're confident. I mean, you can make mistakes. You can get out. It's not like it's not you're handcuffed to it. But boy, from an institutional standpoint, it's hard to get out of a program.
And lawyers don't like change. Let's be honest, right? No one likes change. We're busy lawyers. We want to do our work, and to have to learn another system, another program. It's hard, and that's where that whole change leadership really becomes important. But with all these shiny objects out there, the point that Doug raised about integration, I think, is so important, because whatever is out there, it has to work with your existing infrastructure, and I wouldn't know the first thing about that, right? So it's really good that we have people like Doug out there who can help with that kind of management and that kind of investigation, and then ultimately the implementation as well.
And I will say the integration tool has changed in the last 2 or 3 years so dramatically. Like it is so much easier to be integrating between programs now as a consequence of things like Claude and some of the AI tools that exist. That before, if you said, geez, I want to link PC Law with this program, we were talking about an impossible scenario. But the crossover of that, too, is what we're finding is we use Slack and love it in so many ways. But it's so big that they're not interested in our little problem. And so, we can jab them and give them, and I'm not, dissing them in a sense, but, Slack isn't going to care if I want to, adjust some part of their program. So that when they get so big, they just become untouchable as well.
It's that customer service component that is so important. And that sort of ties into how important the training is and the ongoing training, because these tools are so powerful and we're just, touching the surface for the most part, unless we have that constant teaching. Let's be honest, they're getting stronger, the tools are getting better, and we just need to learn how to use them more efficiently.
Yeah, and we're going to get Doug back for a session on some of his ideas on training and some of the tools that we're using. And I say tools, not AI tools, management tools to get lawyers engaged. And we'll come back to that. But just thinking about the idea of, jumping into the program. I mean, there's still lots of lawyers, statistically, lots of lawyers who don't even know how to spell AI. Like they're literally not, they're waiting it out. With the hope that this is going to be a shiny light that goes out of the way. And I mean, it's a disastrous plan of action. But
I think so.
That being said, there was a great, this week's AI and the Future of Law with Jan Leonard and Bridget McCormick had a great interview about the longevity of AI and the idea that from a legal education standpoint, what's happening revolutionizing the teaching, at schools. There's always that tension at law schools. Do you teach practice? Do you teach academics? Are they supposed to come out and are they supposed to be trained wizards on AI? Or are they supposed to have core understanding of contract law?
Yep.
And they have a great debate on it in the last episode about that tension. But it's interesting because we're going to see where students are going to take it. And as practicing lawyers, we don't even have a clue. We don't even know what AI is going to do to us in 6 months, but we do not know what 5 years from now, trained university and not just law school, university and law school level students are going to, coming into the marketplace. It's going to be interesting to see.
And what they're going to be capable of. I mean, and I think that's a little bit about what, the general public is afraid of. It's like, oh, are we going to lose our jobs? And, I was one of those people at the very outset too, but the more you learn about it and the more you use it and the more you see what it's capable of, you realize that it's just an adjunct to our practice. It's never going to replace us.
And they teased that out in the last podcast of I was talking about where this idea of losing your job as lawyers, all three of the speakers were like, no, that we're not going to lose our advisor role. Like at some point, if we aren't advisors, then what are we anyway?
Exactly. We're not earning our keep.
Yeah. So it's going to be interesting to see. But I'm anxious to see how it gets picked up on. Today, a funny totally random news thought about, I was thinking about comparing to AI was in the UK today, they passed a law that said that if you're 2009 or below, born in 2009 or below, you can never smoke in the UK. And it's so interesting to me because what they've done is they've created a generation, or trying to create a generation of people that are illegal to smoke. And it made me think about students coming into law school now. They're like, this is an outrageously expensive process now. Tuitions are a major undertaking, and they're getting told about some nuance of some case in the 1830s that, it's going to be harder and harder for us to maintain that sort of core academic interest. So we got a whole bunch of students, we got a whole bunch of students coming into law who aren't allowed to smoke. Now, of course, there'll be an underworld of smoked cigarettes all over UK, but no one wants to talk about that. Yeah, but anyway, it's good fun. And it's fun to see, Doug, your views on how to get into it, because it really is, you got to rip the Band-Aid off and get some good advice to get into AI and use it to the extent that it makes sense for your practice, both day to day and financially, and what investment you want to take. So when next time we give you back, Doug, we'll want to talk a lot about that kind of ideas. What is the investment? What does it involve? And what are some of the trips and traps of just getting not just lawyers, but your team engaged in AI usage and tools? Because the last point I'll say is, and I was just literally at a breakfast this morning where I was talking to one of the major, he's a very senior guy at one of the major legal software companies. And he says that they are internally tracking every single employee's usage. Their bonuses are tied to their usage, and they have to track the advances and the savings of time like dockets. And if they don't engage, they show them the door. Now, obviously, they're invested in really making sure that even their teams are deeply involved with AI. But that's a software company, legal software company. I know for sure the consulting industry is doing this too. So it's interesting that we're going to talk the next time about how to soft land and manage people to get involved in AI. But there's also some heavy sticks that are out there that are being used in the marketplace for employees to engage in AI. So we're big fans of friendly and soft landings, but I'm going to be interested to see how the practice.
And Ian, just on the flip side of that, I think one of the things that for people who are in the kind of a role like you and Suzana, who have been running a firm for a long time, I think you are going to start to see a switch where this becomes kind of like a talent management question, right? You're going to start seeing people who are applying and firms who want to keep, really people who are really innovative, great at the jobs. I think this question of, hey, what tools are going to be available to me? How much compute do I have available to me? How much freedom do I have to go and use this stuff and really spread my wings? And I think firms are not quite used to having that discussion, but it's coming, right? That change is coming for us.
No, I agree. And the last thing I'll say to that is that certainly all the big firms in North America, they covet the high mark students, and they think that's the way to go. And I've got lots of theories with that, but that doesn't matter. It's changing with AI, right? Just because you're smart as a whip at law doesn't necessarily mean you're going to be one of those people that are going to embrace and innovate within the tools. So anyway, listen, this has been a great discussion. Doug, we know you're a busy guy, and we appreciate you taking the time to see us in our early days of this podcast. And so we wish you all the best of luck, and we'll get you back to talk about some of the tangibles.
Thank you very much, Doug.
Thank you both for having me.
Thanks a lot.
Take care now.
You have been listening to A Better Place to Be, AI and the Law, with hosts Ian Hull and Suzana Popovic-Montag from Hull & Hull LLP, brought to you by counsel.ai. If you have any questions or comments, please email our office at info@cnsl.ai. Thank you.